Hi, I'm Bradley Bick from Workplace Health and Safety Queensland, and I'm here today to talk to you about the model regulations. In terms of background, the harmonisation of health and safety laws has been occurring since the middle of 2008, and that process was really put forward by the Intergovernmental Agreement where the Commonwealth, state and territory governments agreed to harmonise health and safety laws. That process resulted in the development of the Model Act, and since then the priority has been the development of the model regulations and codes of practice. All the model laws are scheduled to commence on the 1st of January 2012. The regulations really are comparable to the current Queensland regulations, and the reason for that is that they've been developed and based on all the existing regulations across Australia. They've also been developed on national standards, existing national standards and codes of practice. So, for example, the National Standard for Construction Work was used as the basis for the construction regulations themselves. There are also policy decisions made by the Strategic Issues Group for Health and Safety, and that was a tripartite group with all the regulators across, all the health and safety regulators across Australia and the unions and employers at that national table. You might recall that the model regulations were put out for public comment in December 2010 for a period of 4 months, and that closed in April this year. Safe Work Australia received over 1,300 submissions, and those submissions were analysed by the Strategic Issues Group, and that included both employers and unions at that table. The regulations themselves were signed off by the Workplace Relations Ministers in August this year. The regulations themselves, when you look at them, you'll see it is a mix of outcome-focused regulation and some prescription. The prescription really is for those areas of high risk, such as confined spaces, diving and hazardous chemicals. Some of the regulations, the detail that we currently have in our existing Queensland regulations has been moved into the codes of practice. This does allow employers more flexibility in terms of you can follow what's in the code of practice because they are admissible as evidence in court as what is examples of what is reasonably practicable, or you can choose another way to control that particular risk in your workplace. When you look at the structure of the new model regulations, you'll see the early chapters really are topics that apply to all workplaces and all industries regardless of where you are. It then moves into the more hazard-specific areas such as noise, manual tasks, hazardous substances, construction work, and asbestos and major hazard facilities. A question I often get asked at this point in time is what is happening with the mining regulations. While the mining regulations have been drafted, they won't form part of the Queensland's Work Health and Safety Regulation as they'll be dealt with by the Mining Safety Regulator. I should also point out, in terms of electrical safety, while the electrical safety regulations do form part of the model regulations, they will be implemented through the Electrical Safety Regulation 2002. One of the first chapters in the legislation covers representation and participation. This chapter really covers the details about how you'll form work groups in your workplace. It talks about different factors that should be considered by your workforce in determining what those work groups are. And they should be based on things such as geographical location, the type of work, the hours of work, and also the types of the nature of risks of that operation. The legislation also goes on further to cover off the specific health and safety reps training. So they'll be entitled to a 5-day initial training course from their appointment, and then also a 1-day refresher each year after that for the duration of their appointment as a health and safety rep. Finally, that chapter covers issue resolution. This chapter covers the default procedure for issue resolution. As a duty holder, you have a choice to develop your own issue procedure that meets the regulation or cover the procedure that's in the regulation itself. The default procedure covers such things as consideration of the number of workers affected, the likelihood of and consequences of the hazard or risk in your workplace, who should be responsible for resolving that risk, and also looking at things of what is current industry practice in terms of the matter that you're looking at. The General Risk and Workplace Management chapter covers a variety of different matters that apply to all workplaces. The initial part of the chapter covers the risk management process, and for those of you that had a look at the draft model regulations, the draft model regulations didn't have a risk management process. The new version moving forward does have a risk management process within, and it is fairly consistent with Section 27A of our current Workplace Health and Safety Act 1995. The regulation itself requires the duty holder to identify all reasonably foreseeable hazards in their workplace, and then manage those risks by elimination. If you can't eliminate those risks, you need to minimise them. Following that, it requests the duty holder to follow the hierarchy of control when minimising those risks, maintaining those control measures, and then reviewing those implemented control measures. In terms of differences, you can see the process goes from identification straight through to elimination or minimisation. So the risk assessment process of that has been removed from that process. And the reason for that is that we don't want to burden industry with having to do risk assessments when there's a known control for that risk. So for example, if you've got a risk of noise exposure and you know that you can enclose that particular piece of plant to eliminate that noise, there's no need for you to do a risk assessment on that particular topic. You'll also see when it takes you to the hierarchy of control, it actually bands a number of the hierarchy of control together. So it goes from elimination and then it bans substitution, isolation and engineering controls in one step so you can use them as alternatives. Then it goes through to administrative controls and then finally personal protective equipment. In terms of reviewing those implemented control measures, there are a number of triggers in the legislation from the control measure you've implemented isn't working, you've had a notifiable incident at your workplace, or that you're going to introduce a change into your workplace that could potentially introduce a new risk in your workplace. Finally, there's the trigger for the health and safety rep to request that the duty holder do a review where they believe that the review or the control measure in place isn't adequately controlling the risk at hand. The provisions regarding training, information and instruction link back up to Chapter 19 in the Work Health and Safety Act. This provision requires the duty holder to provide information, training and instruction to the workers that is suitable to the needs of the workers and also suitable to the nature and risks of that particular workplace. For example, if you're a workplace that's got multiple duty holders, such as a construction workplace, there are a number of different hazards, there's some complex control measures to eliminate those hazards or risks in that workplace, that your training, information and instruction to your workers will be much more comprehensive. You might have more written documents, you might provide more training sessions. Compared to a low-risk work environment such as myself, I work in an office. Probably the highest risk, I might cut myself on a piece of paper. So the training, instruction and supervision provided to me needs to be of a lesser standard. In terms of the general workplace environment, this is really the provisions that cover your amenities at your workplace. So means of entry and exit, the workspace that your workers are in, looking at your floors and surfaces, how they're designed, maintained and installed. Also talks about adequate lighting, and this will be supported by a general workplace environment code of practice, and it will use some of the more technical standards such as AS 1670, which relates to the lighting standards. It also covers ventilation, extremes in temperature, controlling risks with essential services, so that's about working in or on essential services such as electricity, water, sewerage into your workplaces. And it also covers adequate facility for workers, and that includes things such as toilets, drinking water, washing and eating facilities. And the code of practice that supports this document will cover such things as the ratio of toilets required depending on the number of male and female workers in your workplace. The next part of this chapter covers first aid. This provision is not qualified by so far as reasonably practicable, and that means regardless you must ensure first aid is provided in your workplace. Again, first aid must be provided, it must be suitable to the needs of the workplace and relevant to the nature and risks of the operation itself. There's also a requirement to have adequate trained first aid officers within that business, and that also needs to be dependent on the nature of risks. If you've got a very complex workplace with high risks, it might be you have an occupational health nurse and you might have a full health and safety room. For an office, you might have an agreement with the medical centre which is directly across the road from you. So you might not need to have trained first aid personnel in your workplace, depending on the needs. And these provisions will also be supported by a National Code of Practice for first aid. Emergency plans is another area of the regulation, and this is a new area of regulation for Queensland, particularly in workplace health and safety. In our businesses, we often have the little plaque that sits inside a door that says, "You are here, your emergency equipment is here," and that document is required under the Building Fire Safety regulations. This is not a duplication of the requirements. The requirement for emergency plan under this regulation is a broader requirement, and that fire safety plan would just form one part. So it's not about people having two plans, and it's not about duplicating existing requirements. The emergency plan itself has to cover all foreseeable emergencies. So for example, if you're working beside a chemical manufacturer, your emergency plan reasonably foreseeably could cover such a thing as a chemical leak that might expose your workers to fumes because they're working right next door to that person. There's also a requirement for workers to be given training and information in your emergency plans, and for your emergency plans to be implemented and tested on a regular basis. In terms of personal protective equipment, the legislation provides that where you have identified PPE as a control measure, it is up to the duty holder to provide that personal protective equipment. That protective equipment must be suitable to the worker and suitable to the nature and risks of the workplace. So if you're using a particular air-supplied respirator, that respirator needs to be suitable for the hazardous contaminants that are in that environment at that time. You must also provide your workers with training and information and instruction about how to use that personal protective equipment appropriately. The provision itself has caused a lot of discussion in terms of that it is up to the duty holder to provide that personal protective equipment, and that does cover everything from safety boots through to prescription safety goggles if you prescribe safety goggles as a control measure in your organisation. And I think this highlights the importance of the provisions in the legislation in the Work Health and Safety Act that talks about consultation, cooperation and coordination. Each person conducting a business or undertaking will have to ensure that workers are provided with personal protective equipment. So, for example, a labour hire company is a person conducting a business or undertaking, they would have a duty to provide personal protective equipment to their workers. That worker then is placed with a host employer. That host employer is also a person conducting a business or undertaking and has the same duty to provide personal protective equipment to that worker. So through consultation, cooperation and coordination, both PCBUs don't need to provide personal protective equipment, but one of them does, and they need to work that out through agreement. Remote and isolated work is another area covered in the legislation. This provision really is limited to providing an effective means of communication for those workers that are remote and isolated workers. And by that I mean they're remote from the assistance of emergency services. Some good examples are we could have a community nurse that's working in the middle of the city. She might be working at midnight doing some clinical visits. It might be appropriate or reasonably practicable for her to have a duress alarm on her that she can contact her employer in case she gets in trouble, but she could be considered a remote and isolated worker. In contrast, you could have 100 workers in a base camp out in the back of Queensland. They would also be considered remote and isolated workers, even though there would be 100 of them. In that situation, probably a good example of what's reasonably practicable for those workers would be access to a satellite phone. And it doesn't mean every worker has to have a satellite phone, but the persons conducting a business or undertaking need to ensure that workers do have access to it and that they're trained and given some information and advice on where they can access that. So each PCBU involved in that particular work, they don't need to provide a satellite phone each, but they do need to ensure that that effective means of communication is provided. And that will also be supported with details in the Model Code of Practice for Workplace Environment. There's also requirements in terms of managing risk from contaminants in your workplace. If you don't have hazardous substances or hazardous chemicals in your workplace, this provision probably is not as relevant to you as someone who might be a spray painter, for example. Basically, this provision requires the duty holder to ensure that atmospheric contaminants in your workplace do not exceed exposure standards. The provision itself requires the duty holder to conduct atmospheric monitoring if they're not aware of what the current levels are and if they're not certain that those exposure standards are not going to be exceeded in that workplace. In terms of hazardous atmospheres, the legislation also covers these, and these are things such as confined spaces, your silos, your cold rooms, for example. These are areas that might have unsafe oxygen levels or atmospheres that might be highly explosive, such as a flour mill where there's dust that can get to a level that is in a highly explosive mix. This provision requires a duty holder to manage the risks associated with an ignition source in those hazardous atmospheres. The storage of ignition sources is also covered by the legislation. Basically, this provision requires the employer to, or the duty holder to, keep flammable combustible liquids at that workplace at a level that's as low as reasonably practicable. Finally, the last chapter in this general workplace environment is falling objects. And this area in Queensland has always been dealt with more specifically in the construction industry, but this will now apply across all industries and all workplaces in Queensland. There are two elements to this provision. Basically, it says that the duty holder must manage the risk of an object falling on a person if it's likely to cause injury to that person. So, do you have a risk of a falling object, and is that falling object likely to cause that person an injury? A good example is if I'm lifting down boxes of ping pong balls, apart from embarrassing myself, those ping pong balls are really not going to cause me any injury. If I was lifting down the same box, but that box was full of bowling balls, that really could cause me quite a significant injury, and that the duty holder has an obligation to minimise or eliminate that risk of those falling objects. This will apply particularly in the transport and also in the retail and wholesale sectors where products are stored in long warehouses through stacking systems, and there'll need to be some processes in place to ensure that those objects do not fall and injure people.